Welcome, everybody. Thank you very much for coming today to the Hoover Institution for a discussion of conservatism and executive power. Now, this seems the ideal moment to have such a conversation, precisely because we don't know where we'll be a year from now. This truly is a veil of ignorance. The Republican Party and the Democrats don't yet know who their nominee will be for the presidency, and neither party knows who ultimately will occupy the White House a year from now. And so, behind this veil of ignorance, we can sit back and more objectively discuss how conservatives should think about executive power, how conservatism in principle relates to the idea of executive power and legislative power. Now, I looked back where we were about this time in the last major presidential election cycle in 2008 and came across a quote that gets repeated back from time to time from President Obama, March 31st, 2008. He said to an audience in Lancaster, Pennsylvania, the biggest problems that we're facing right now have to do with George Bush trying to bring more and more power into the executive branch and not go through Congress at all. And that's what I intend to reverse when I'm president of the United States of America. It may not have quite turned out that way, and it might have something to do with the fact that where you stand often depends on where you sit. But I happen to be seated with three widely esteemed experts on constitutionalism and on executive and legislative power. And so it's my pleasure to convene this conversation with them. And I'll introduce them beginning right here at my right. James Caesar is a senior fellow at the Hoover Institution, and he's the Harry F. Byrd Professor of Politics at the University of Virginia and director of the Program for Constitutionalism and Democracy. He's the author of several books on American politics and American political thought, including Presidential Selection, Theory and Development, and he's a frequent contributor to the popular press. In 2015, he was awarded the prestigious Bradley Prize. Seated next to him is Professor Jonathan Turley, who holds the prestigious Shapiro Chair for Public Interest Law at the George Washington University Law School, where he teaches and writes on a range of subjects, including constitutional law. He's a nationally recognized scholar, but also an active practitioner, representing clients in a number of significant cases, raising fundamental questions of constitutional law, constitutional checks and balances. In 2011, he filed a challenge to the Libyan war on behalf of 10 members of Congress. In 2014, he became lead counsel to the U.S. House of Representatives in its constitutional challenge to President Obama's modifications of the Affordable Care Act. That case is still pending. The litigation was approved by the House of Representatives to seek judicial review of claims under the separation of powers. And your bio also indicates that you've represented workers at the famously secret Area 51 Air Force Base. Finally, to his right is Yuval Levin, founding editor of National Affairs and a Hertog Fellow at the Ethics and Public Policy Center. He's the author of several books, most recently The Great Debate, Edmund Burke, Thomas Paine, and The Birth of Right and Left. His next book, on what he's described as our fractured republic, when's it due out?
At the end of May.
Good. Off beach reading, offers a vision of how, as he put it, how America can overcome nostalgia, revive civil society, and thrive in the 21st century. He was awarded the Bradley Prize in 2013. So please, everybody, let's welcome him. Now let's begin one at a time. We'll begin with Jim, and then Yuval and Jonathan on the most open-ended of questions. How should conservatives think of executive power?
Well, Adam, I'd like to thank you and Hoover for everything this afternoon, except perhaps for the title of this session, Conservatism and the Executive Power, because there is, or at least there should be, no conservative view of the power of the presidency. There should only be a constitutional view of the power of the presidency. If the views of the presidency derive from conservatism, whatever conservatism may mean, rather than from the Constitution, if they're meant to promote conservative goals or cover up for conservative errors or the errors of conservatives, they really hold no interest for me, and I don't think they should hold much interest for you either. Or if they should hold maybe a little bit of interest, it's of the sort that interests intellectual historians who like to waste their time and ours cataloging such views. These views, that is, what people have said from the point of view of conservatism, really are can't be genuine, and they can't be normative for what we think. I'd relent only to this degree, if some conservatives should happen to have a view of an executive power different from that of the Constitution. If some of the conservatives I know really prefer a medieval king with pomp and circumstances and urban roads and all that, it might be worthwhile as an intellectual exercise to present a conservative vision like that, but don't try and sneak it in, or any other conservative view, under what we mean by the U.S. Constitution. It's only the law, I think, that counts. Now, fortunately, if pressed, I think most conservatives would agree with this because of their commitment to the Constitution and because of the concept of the rule of law. They generally believe that these concepts are normative. And if conservatives stray from this standard, they do so from human frailty or sometimes from partisan exuberance. They find themselves slipping into the air of allowing their principles to be shaped by the politics of the moment rather than vice versa. But conservatives, for the most part, can be called back from this precipice and meant to feel a sense of shame or remorse if they base their views only on conservative ideas. And they repent by going back to the Constitution, trying their best to figure out what it really means. Their agonies produce elaborate doctrines of interpretation, like the unitary executive, or the Federalist Society certainly will step in to spend considerable money and give considerable weight, agonizing over the meaning of the Constitution, and that's proper. I'd like to be able to say the same thing about progressives and their view of constitutionalism, but I cannot. For what we know about progressivism by its own admission is that the Constitution is not considered normative, at least the Constitution in its original sense. Progressives take their bearings from certain higher sources. Could be progress, equality, cosmopolitan community, or whatever. And shifting ideas about institutions, if they promote these higher goals and values, are welcome without any sense of remorse. So whatever the president said in Lancaster, I don't think he felt necessarily held to it as a progressive. Constitutionalists have been amazed and dismayed at President Obama's expansion of executive power, especially in the domestic sphere. He has pronounced, however, no real doctrine for doing so, other than something like, we can't wait, and we have to change these things. Or he's relied on the conventional wisdom in Washington, which says that government is dysfunctional, and dysfunctional means that it's not progressive, and therefore, under this emergency of dysfunctionality, he's required to step in. But really, there hasn't been much of a doctrine. What he has perhaps done, as president, is brought this idea of governing by decree into the light, because when this was done before, usually it was done with all sorts of explanations. It was hidden when it couldn't be justified, but now it's promoted openly to the cheers of the progressive partisans. That's probably the danger of a change in our whole constitutional structure. But this has to be said about the progressives. In their tactical maneuvering, they created one doctrine in the 1970s that has shaped a great deal of thinking, not only of those on the left, but has influenced those on the right as well. And it comes from the term that has become synonymous with concern about the presidency, namely this term, the imperial presidency. This comes from a book by Arthur Schlesinger, a remarkably influential book published in 1973. And what's interesting about this book, despite it coming from the progressive side, it poses and in fact proceeds in an entirely originalist way. It's amazing in some way when you look back that this party that generally is very loose about relying on the founders and constitutional thought presented its most important idea by relying almost exclusively on a version of originalism. and are trying to argue by looking at the founders, the Constitution, and whatnot, tried to argue for a much more limited role for the presidency in the area of national security. Interestingly, when you read that book, it's very nice. It talks all about the founders' views as they understand them, Schlesinger and his followers, for foreign affairs, and never mentions very much about domestic affairs except Nixon's several excesses. The other part of the presidency, the activist part, the Roosevelt part, is generally treated as fine and not causing any constitutional dilemmas whatsoever. So it was a version of originalism that is stuck with many in American politics, and as I said, has turned this discussion from the left on this point very frequently into legal terms. Now this brings me to my final point and warning for conservatives who are obviously today alarmed at an executive that they fear has grown way too strong, and then they make the mistake of using this term imperial, like everyone else, thereby maybe buying into the Schlesinger line. The warning is that conservatives, and here's the warning, is that they are falling prey to the disease of conflationitis. Conflationitis overlooks an essential distinction in the Constitution and in constitutional thought in favor of speaking simply and simplistically of a strong or weak president. It makes the discussion about the executive one-dimensional. So by this logic, it overlooks this fundamental distinction, which I think is deep in the Constitution and deep also in constitutional thought, between the zone or the empire of law, the area where people understood that human affairs could be governed more or less by statutes and laws, precise ideas of what we should and shouldn't do. This area, or this power, is vested in the Congress plus the president in his veto respect. But there's another area inside constitutional thought, which you could say is the realm of discretion. This is an understanding of the realm of human affairs that can't be governed or governed easily by legal norms and laws. Decisions about what to do tomorrow, who to recognize in a foreign country, when to threaten, when to bomb, things like this. I don't think that this can be governed by laws. I don't think the founders thought that it could be governed by laws in the same sense as they are in domestic affairs. So this distinction between the empire of laws and the empire of discretion is crucial to the Constitution and constitutional understanding. The president obviously has a much greater degree of control in the realm of discretion. This is what the executive power, at least for many, meant. The realm of law is vested more clearly in the Congress and the president in his veto capacity. Now, by forgetting about this distinction and adopting this conflationist view, conservatives risk today embracing the idea of accepting a weak presidency and a weak executive across the board. In their anxiousness to get Obama, they will oppose not only his usurpations in the domestic realm, or as I call it, the realm of law, but also in the realm of discretion and in the realm of national security. They're only too happy today, conservatives, to pounce on Obama for all the things that Schlesinger spoke of, namely a president who's overbearing and going too far by his view in foreign affairs. Constitutionalists should take a different view. In the zone of law, they should be firm in restoring the rule of law. In the zone of discretion, they should pocket many of the president's claims and practices. No matter how much conservative constitutionalists might disagree with how Obama has used his discretionary power in some instances in national security, what matters from a constitutional perspective is that he used them. Let progressives be tied to this masthead in the future.
Thanks, Jim. Before I move on, I just have to say about Arthur Schlesinger. There's a new book out recently by a distinguished senior fellow at Hoover, Neil Ferguson, a biography of Henry Kissinger. And there's an episode early in it where Kissinger is hanging around the Kennedy administration. He's talking with his Harvard colleague, Schlesinger. And Schlesinger is complaining that the bureaucracy keeps getting in the way of all these things that the president wants to do. And if only the bureaucracy would step back and allow President Kennedy to really move forward on what's important, everything would be fixed. But I guess he changed his mind a little bit.
Well, he never included that really within the imperial presidency. That is the trick of the book. It's a limitation of presidential power almost exclusively in the realm of national security and foreign affairs. That's the part that stuck, and as I said, to reiterate the point, it strikes me that the conservatives are so anxious, using the word imperial, to take the president down, that they're going to swallow that and accept the other part of Schlesinger.
Well, thanks, Jim. Now, having been embarrassed by the faulty premise of the conversation, conservatism and executive power, I'm tempted to just conclude the conversation. We can head back to the bar. But unless if you'd like to offer any thoughts.
Well, let me say I speak keenly aware of the most basic rule of constitutional argument, which is that to the extent that you disagree with Jim Caesar, you're mistaken. I'm going to try to limit my errors here. But I do think that the question of where to draw the line between the realm of law and the realm of discretion is really another way of describing the question of presidential power and congressional power, and that presents us with the great challenge of finding a balance, which is what I think as a practical matter friends of the Constitution always have to try to do, to lean against the system where it threatens to fall over. And to my mind, the question of conservatives in the executive now is that question. The question of constitutionalists in the executive now is about where to find that balance. Which way is the system threatening to fall over, and which way should we push and lean against it? I think we're meeting at a moment where maybe more than at any other time in the modern era, it should be clear to conservatives that enlightened statesmen will not always be at the helm. After 8 years of seeing what pernicious effect the use of executive power can have in the hands of liberals who are dedicated to overcoming the boundaries of the constitutional system, and now in the course of a presidential campaign when we see before us the possibility of really a kind of pernicious demagogue taking over the executive power in our system, we should be most able to resist the temptation to think about executive power only in terms of how it might be used aggressively to advance our policy objectives. And we might even find an opportunity to think about executive power in terms of how it might be limited effectively to advance our policy objectives, and in any case, in how it might be appropriately balanced. And it seems to me that over the past several decades, the powers in our system of government have fallen out of balance, especially in the executive, especially in the domestic arena, where it does seem to me that the executive has taken for himself an enormous amount of power that is not properly his. And I don't just mean President Obama. I think this has happened over a number of decades, and it's happened thanks to presidents of both parties, and even more so, I would say, thanks to Congresses of both parties. Congress has willingly ceded power to the executive over and over, knowingly, intentionally, both because members don't want to make hard choices or be held responsible for them, and because members think that a president of their own party will be better able to advance their policy objective than they themselves will. We've seen again and again Congress ceding power to the executive. And we've seen in the last two presidencies a number of instances in which the executive just kind of abjectly shames the Congress. We've had an occasion where President Obama puts out a statement of administration policy saying he agrees with what Congress is trying to do. This is in one of the Obamacare instances, the limitation of the individual mandate. He agrees with what they're trying to do, but he thinks it would be better if he just did it himself by executive action, and then being praised by congressional Democrats for doing that. I think that our system of government assumes that the people occupying all three branches will be ambitious, and that their ambition will counteract the ambitions of the others. And we have seen in the past few decades a failure of congressional ambition, one of the results of which has been a kind of inflated executive in our system that, again, especially in domestic affairs, has gotten out of control. And to the extent that friends of the Constitution want to step in and help the system work better, they will need to step in to empower Congress and to somewhat weaken the executive, especially in domestic affairs, so that if, as Jim says, conservatives are friends of the Constitution in our system, then we do need to be thinking about that balance now. And it seems to me that we do need to look for ways to relatively strengthen the Congress and relatively weaken the executive. Now, the natural response to that, as Jim suggests, is to say that, well, conservatives are out of power now in the executive, and they've been in power in Congress more commonly in the last few decades. And so we've just come to the view that Congress is better because we're just more likely to run Congress. I think there's no denying that some of that has happened, and it has to be separated from the actual constitutional argument, from the actual looking at the circumstances of the constitutional system, thinking about where it's fallen out of balance and why. And I would not argue that congressional power is inherently friendlier to conservative ends or to a conservative vision of the Constitution. But at the same time, I would not argue that calling for strengthening Congress now in relation to the executive is merely a kind of politically useful argument to make because of the current state of our elected branches. I think that it has to do with the circumstances of our constitutional system. The goal to be served is a balanced system in which the branches counterbalance one another and work effectively together. And I think the way in which the system is now out of balance requires us to push back against executive power, especially in the domestic realm. Now, what that ought to look like, I think reformers have to think about past attempts to do this, and maybe especially the attempts made in the 1970s to rein in executive power and to strengthen the Congress, which I think on the whole did not succeed. And those attempts had to do with a kind of consolidation of congressional power, trying to make the Congress look a little more like the executive branch. And so to give the Congress its own administrative agencies, to give it a much more consolidated budget process. I think today's reformers should think in the other direction, to make the entire process play to Congress's strengths more and play less to the president's strengths, to make the budget process less centralized, to break it up into smaller pieces, so that what's happening in Washington most of the time is legislation, rather than the kind of reversal of the process that we've seen, where today's budget process is a reverse constitutional process. The president, as first mover, has enormous control of the agenda, and Congress once a year gets a veto over one big budget bill, yes or no. It seems to me that the way to get back to a more functional constitutional system would involve breaking that process up a little bit with an eye toward a stronger Congress and, at this point, a weaker executive. I think friends of the Constitution should not be afraid to think in terms of contemporary challenges rather than just in terms of a kind of absolute principle and an absolute distinction between where the realm of discretion begins and ends and where the realm of law begins and ends. Our system inevitably will push too far in one direction or another at any given time, and the friends of the system have to be friends of a balanced constitutional process, which does seem to me today to suggest that we have to be more critical of executive power in domestic affairs and more friendly to a stronger Congress.
Thank you very much. Jonathan, you're not somebody who normally self-identifies as a conservative. Is that fair to say? Which is why it's been particularly interesting and impressive to watch your work in the last several years, where you're representing the U.S. House of Representatives in this lawsuit against President Obama. So we're very, very interested to hear your thoughts on the subject and about executive power more generally.
Well, thank you very much. I should say at the outset that what should be obvious is that I'm speaking today as an academic, not as lead counsel for the House of Representatives in the ACA lawsuit. So all the mistakes are my own. I come to this with a different perspective, certainly. I don't view this as a matter of conservatives versus liberals. I never have. You don't come to Washington for principles. In fact, you need waiters most days to get through the streets because of the hypocrisy on issues like constitutional law. That's the unfortunate life of someone who teaches constitutional law in the city, is that your allies change fairly continually. But there are people with principles in the city. There are people with principles in Congress. And so I view the division as between constitutionalists and opportunists. Constitutionalists know that the meaning of principle is to sometimes do things that you don't want to do because you have to do them. And that means going back to first principles with the framers. And in that sense, I am a dinosaur. I'm a Madisonian scholar. I believe very strongly in the vision that James Madison laid out. And I believe that, if anything, our current chaos and dysfunctional politics have vindicated James Madison, that the system works better when you stay within the lines. The primary principle that the separation of powers is based on is to avoid the concentration of power in any one branch or in any one hand. That's the reason, even though I voted for President Obama in his first election, and I support many things that he works for, I think he's wrong. And I think that what he's doing is dangerous for the system. Because this entire system is based on the idea that the concentration of power is a threat to personal liberty, to individual rights. That's what separation of powers is. It's not there to protect the branches. The framers were very clear. They wanted to protect individual rights from the concentration of power. So what you see around you is in many ways the vindication of what they talked about. You get a better result in terms of government when it is divided, when it's divided between the branches. Things get worked out. There's no option, as the president suggested, to go it alone. That's the very antithesis of our system. When you are facing a hostile Congress, you have only two choices. One is to change Congress. The president tried that and failed. The other is to compromise, to convince people. Those are the only two options you have. So for a Madisonian scholar, one of the most confusing things I've ever witnessed in my life was when President Obama spoke at the State of the Union and told Congress that he intended to circumvent them, that he was tired of waiting for them to do what he had requested. Now, that's not anything new. Presidents, Democratic and Republican, have tended to go in that direction. But what was a bit odd was what followed that statement, which was rapturous applause from half of the body. You had these Democratic members wildly applauding the concept of their own obsolescence, that they were wildly applauding a president saying that he would effectively become a government unto himself. In that sense, perhaps we're worse than Madison anticipated. We've certainly challenged his idea that was discussed earlier, that ambition would fight ambition. Madison truly did believe that regardless of who was president, that the legislative branch would fight jealously for its own protection. The interesting thing to me about presidential power is even though every president has gravitated towards the concentration of power, it has tended to work badly. It has tended not to reach good results. That when presidents succeeded in concentrating power, they tended to make mistakes. And they tended not to bring the American people with them. You can see that with President Obama. These unilateral actions haven't really moved the needle at all in terms of how people feel towards immigration, towards climate change, towards any of the issues that divide us. There's a reason why Congress hasn't done much in those areas, because we're divided as a nation. And when we are divided, less gets done until somebody convinces somebody else. But when you muscle through on unilateral action, what you get is raw, unvetted, and usually substandard work. A good example of that, by the way, is what actually went through Congress, which was the ACA. No matter how you feel about national health care, and I happen to support national health care, but the ACA wasn't ready to be enacted. I don't know anyone, Democratic or Republican, who believes that was a good piece of legislation. I mean, it was in horrendous shape. And it largely was pushed through on a muscle play because of the death of Senator Kennedy, and it couldn't go back to the Senate. But the result was terrible. FDR had the right idea about one aspect of being president. He refused to get a vote to go to war until he could get as many people as possible to support it. That should have been the approach on things like health care. When you adopt something that massive, something that significant, it's not enough for a president to say, I can muscle it through on 3, 4, 5 votes. It's not enough to say I could do it alone. Because what you leave is that unresolved political question that corrodes the country. So in terms of how conservatives should respond, I'd say you should respond as constitutionalists, not as conservatives. And perhaps perhaps we should actually try principle for a chance. You know, what's interesting is I think President Obama would have been a successful president if he had stuck with principle. He might have gotten less done on something like the ACA. Maybe the ACA might have been broken into 5 pieces. But what he would have gotten done would have been a better quality product, and it would have had the support of Congress. But the siren's call of every party that comes into power is to go it alone because you feel vindicated. Another confusing moment that I experienced, and I must admit I live in confusion for the last 8 years or so, actually more than that, because I was pretty confused under George Bush, is when Attorney General Eric Holder went to my alma mater in Northwestern and announced the kill list policy. Now, he was speaking to a group of judges and lawyers and law students and law professors. And he told them that the president had come up with a formal policy that he would have the right to kill any one of them on his sole discretion, without a charge, certainly not without a conviction. And what met that statement was not guffaws or opposition, it was applause. A group of lawyers and judges applauded the concept that the President of the United States could kill any one of them if he felt that they were a national security threat. That's the concentration of power, and that's also the lack of principle. The idea that we can't live within the Constitution and facing national security threats is as close as we get to constitutional defamation. The one thing we can recommend our country and our Constitution for is that we're still here. You know, you want a beautiful Constitution? Look at any of one of the constitutions written by the French. Those constitutions are beautiful, and they're plural because they failed so often. Our Constitution is not necessarily a beautiful document. It was written by the ultimate geek, sort of a wonky document. But it's still here because it's designed to take the things that divide us, the factions, and to force them into Congress, and to take factional disputes and produce majoritarian compromise. There's no shortcuts. Presidential power, as it has grown, is endangering that system. It's creating instability. It's taking a system that has been through incredible crises, incredible threats, and it's turning it into something else. So with people who try to draw this distinction with, well, you know, we're going to keep the president between the lines for domestic policy, but when it comes to foreign policy, we're going to give him discretion. It's one of the oldest siren calls we've heard in the Republic. The president has to live within the Constitution. It works just fine. And he has to convince people when we take major action. And when he does, there's nothing that can stand in the way of this country. We've proven that over and over again. You just have to get our consent. So what I would say to conservatives, I'd say really to constitutionalists, if you want stability and strength in this country, you don't have to look very far. It's the first 3 articles of the Constitution. You stay within the lines, you'll be a successful president. If you do what your predecessors have done, come into power and do things just because you can, I promise you, it will not turn out well. You will get what you want in the short term, but legacy will be your judge.
Well, thank you all 3, and we're going to have some time for Q&A, but at first, if you'll humor a few questions from me. And I would like to turn to the point that you raised, Jonathan, about returning to first principles. Right, we've talked a lot about Madison, a lot about ambition, checking ambition, but there were other framers, including some who had an influential voice at the time of the Constitution's drafting and ratification, Alexander Hamilton. Right, he famously said in Federalist 70 that energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks, and it is not less essential to the steady administration of the laws. And that's obviously a very famous line, but he made a second point which goes to a phrase you've all used about the first mover advantage. Right? Hamilton recognized this early on, not in the Federalist, but in his debates with Madison. The Pacificus Papers, a quote that's always stuck with me. He said, "The legislature is free to perform its own duties according to its own sense of them, though the executive, in the exercise of its constitutional powers, may establish an antecedent state of things which ought to weigh in legislative decisions." So Hamilton recognized, it seems, that there was this first mover advantage that the president held. And so I guess my question is, do you think our present state of affairs proves that Hamilton was wrong in principle, or that these things shouldn't have been lauded? Or rather, do you think that we've gone beyond what even Hamilton anticipated 200 years ago?
Is that to me, or do you want to start?
To anybody, actually, all three.
Well, sure. I think that part of the answer to that question has to do with the scope of government action in our country, federal government action, which I think is just dramatically different from what Hamilton had in mind. Hamilton says, I think in Federalist 37, that one of the reasons not to worry about the federal government encroaching on the states is that the federal government would never get involved in little things like farm prices. And he gives this list of things. There are just no one who had the ambition to run for federal office would ever be interested in such petty nonsense. And our government has gotten involved in those things very deeply and profoundly. And that means that it requires a level of administration that I don't think Hamilton, in fact, envisioned. And it seems to me that that, combined with the kind of first mover advantage that he had in mind, leaves you with an out-of-balance constitutional system, so that the kind of government we have now requires that we do constrain the power of the executive as an administrator, because otherwise not much would be left of the separation of powers in our system.
Well, Jonathan, what would you say then? I mean, do you think that the problem is executive power rooted in the expansion of federal government, or would you say that it's a separate problem also?
Oh, I think it is. I would agree entirely with that. That is, we're clearly dealing with a government that's very different from what the framers anticipated. Back at the beginning of the Republic, we had 1,000 federal employees other than non-military. So it's smaller than most town administrations. It was a very small footprint of a government. Also, you're talking about a time when even the creation of the first army was opposed in terms of presidential power. You had many people who feared the concentration in a single person, including those suggesting we should have 3 people, a committee that's exercising these powers. So I think it's what he was referring to was a different time, but I think you're right in the sense that the framers did want the president to be able to exercise discretion. We're not debating that. What bothers me about the expansion of presidential power, the sort of uber presidency that we have seen emerge, not just from Obama, but particularly with the combination of George W. Bush and Obama, is that it has no limiting principles. You know, that oftentimes presidents are treating Congress as an option. That's one of the reasons both Democrats and Republicans opposed the Libyan war. You know, the position of President Obama in the Libyan war, and this is in his papers, was that the requirement to get a declaration of war is not triggered until we call it a war. So since they called it a limited kinetic action, whatever that may be, it was not a war. And one of the things that we argued in court was, does that track? No matter what you may think about the framers, these were extremely bright individuals. Does it track that they would create Article 1, Article 2, and Article 3, and do this synergy between these articles, this careful balance of these 3 bodies in locked orbit? But all the president has to do is just not use the noun, and that is all the framers were concerned with? That's the level of lunacy that we have gotten to. And what's really a troubling aspect about all this is that Congress has not been an impediment to presidents. When presidents have faced national security issues, if anything, Congress has been too yielding, not questioning enough. And so when presidents go it alone on things like Libya, it's particularly baffling because Congress has not played a counterproductive or opposing role, even when presidents are from the other party.
Jim?
Well, we disagree completely on that last point. I don't think Libya was a war or anything close to a war. I think the actual meaning of a war, meaning sending a lot of troops somewhere for a long time, we've worked this out, maybe not by a Supreme Court decision, but if you want to start a real war, that is, you have to get not a declaration of war, that's died of desuetude, but you have to get an authorization of force resolution. That was determined de facto in the lead up to the first Gulf War, when President Bush, the first, more or less claimed, I could send these troops over if I want to, and Congress says, yeah, try it, and he backed down. What happened in Libya does not strike me as a war. It's sending up some planes and bombing them. It's a certain kind of use of force, which is in another zone, and President Obama's problem was that he got entangled with the War Powers resolutions and War Powers bill, which I think is of dubious constitutionality anyhow. But anyhow, other instances of the use of force would fall, in my view, outside of the realm. And so this question comes up, especially I'm concerned, obviously, about national security and the use of the president's power. I don't think that the Constitution, separation of powers, is best described as just a balancing among the institutions. That's one part of it, and obviously an important part. The other part is, though, is that there are different tasks of the institutions in different realms. And one of the realms is in the place where you need discretion and where law can't govern. And the question is, what you do in those areas. I'm not for an absolute vesting of that power entirely in the president, but it surely is different than any other realm. And it was surely intended to be different than those in any other realm. In addition to which, I don't think Madison really played a very important role in forming the presidency. I don't think he understood the presidency. Go back and read the notes of the Constitutional Convention.
And badly.
Yeah.
I think he didn't quite understand the presidency very well. He didn't play an important role in it. But that said, the convention isn't the only place to look for this. There were others who were more important, I think, Morris being one example. And I think that Washington siding with Hamilton, he sat through the convention too, gave a better view. We wouldn't have had the executive at all in the American context, and people wouldn't have fought for the executive the way that they did unless they saw the need for something like some sort of moving force inside the realm of discretion and security. That was, I think, the key to the whole Constitution, is the recognition that you needed a federal government for national security, and you needed an institution inside the federal government that was particularly or peculiarly charged with that function. So I don't say unlimited, but I say you can't look at separation of powers as just a balancing.
All right. Where shall I begin? First, beware of those who suggest you go to another world where the rule of law doesn't apply. The framers never spoke of such a place. The framers were committed to the rule of law because they believed very strongly that competing interests make for better action. They would never have suggested that the president has some domain, some netherworld, where his discretion reigns and the law does not. I don't know of any support for that. I also don't know where the idea comes from that wars are sending troops someplace in large numbers to stay for a long time. I don't know where that comes from. In Libya, we sent over a massive number of ordnance. We bombed a capital city. We took out armored columns. We spent a considerable time fighting a government. Now, I don't know what war is. I sure don't know what a limited kinetic action is. But I'm pretty sure the framers wanted that to go through Congress. But putting aside that debate, one of the things where we disagree, and I have a great deal of respect for James, but where we disagree is, I'm working on a book on what I call con-architectural theory, which is an idea looking at structure, how important structure is to the Constitution. And the premise of the book is that the framers, including Madison, created this structure of the Constitution, much of what's called choice architecture. That is, just as Winston Churchill said, that we make buildings and then buildings make us. Winston Churchill was referring to the fact that we are influenced by the buildings we live in. The Constitution works the same way. We have a structure that's designed to actually force us to deal with each other, to resolve questions. It's choice architecture. And when you have the suggestion that, yeah, that's fine and good for domestic stuff, but there's this netherworld that's outside those lines of separation, that's a dangerous thing, because we've seen how most everything can be translated into a national security problem. And that is the one, you can't have an exit ramp in this system. You have to stay between those lines, and that's where we disagree.
Now, I actually have authorization for the use of moderator force, so I'm going to push us into a slightly different subject. There's a point that, Jim, you raised that really jumped out at me, where you said that for a long time, a lot of what had been done through executive power was done in the shadows, right? And you said one of the innovations of the last few years has been to bring it out of the shadows and just do it sort of boldly for the front of the American people. And for all the panelists, I'm curious, what's changed in recent years that have emboldened presidents to do this? President Bush was no real slouch at this either, in signing statements and elsewhere. What's changed? The presidents have felt freer to take unilateral action in public. Yuval?
Well, first I'd say a lot is still done in the shadows, quite a lot. If you read the Federal Register on Fridays, you will find a lot of unusual things happening, and they are happening in the shadows. An enormous amount of the use of executive power under this administration has happened in ways that are intended to be hidden, and that are often effectively hidden. I do think, though, that part of what's changed over the last several decades, and it's not just under this administration, is the partisan polarization of our national politics, which means that the competing ambitions of our institutions on the one hand and the competing ambitions of our parties on the other hand are pushing in different directions. And members of Congress understand their interests to be advanced by an assertive executive if he is of their party. And so they're willing to see the executive overreach. And again, my experience is mostly on the domestic side, and I think the domestic and foreign affairs are different when it comes to interbranch relations, and they should be different. This certainly happened in the Bush years. That is, when I worked in the Bush White House, we very frequently had Republican members of Congress ask the president to do things that they themselves should have done and could have done. Because they didn't want it to be that public, because they didn't want to be responsible for it, it wasn't clear if it would work out, whatever the reason. It happened a lot, and I'm certain that it's happened a lot between this president and Democrats in Congress. Some of it's been very public, as we've heard, and some of it is not public. But I do think that the greater partisanship of our system at the national level just means that there are still ambitions counteracting ambitions, but they're not just institutional. And you know, presidents and Congresses are much more willing to do that in the open than they might have been before.
We'll have Q&A in just a moment, but Professor Turley, you have to leave a little bit early to go teach your students, and I want to get one more question in with you. Obviously, the main forum in which you've tried to reassert separation of powers has been in the courts. And I'm curious for you and for the other two, what role you see the courts playing, what role should they play, what role should they not play in enforcing the separation of powers and checks and balances?
Well, you know, I've been very critical in my writings of how courts have removed themselves from separation of powers conflicts. In fact, I don't blame the two parties. I agree with everything you said about the partisanship in Washington. But I don't blame the two parties for the dysfunctional politics we have. I blame the courts. Because the thing is, the courts have left these parties with just muscle plays. They constantly remove themselves. They abstain from cases, or they say that there's no standing to bring cases, which is expanded to a grotesque point. And so the result is that no one's mining the line of separation. In my view, the most critical function of the court is to deal with separation of powers fights. Not saying who wins, who loses, but who makes those decisions. And as the courts pull themselves out of that, in my view, improperly, you've had the increase of these muscle plays, this dysfunctional type of politics. There are plenty of principled people in Congress. We make jokes. I made a joke. But there are principled people in Congress. There are people who care deeply about the Constitution. But they also are trying to get things done for their party, things that they happen to believe in, by the way. It's not all just trying to get the other guy. These are people who are actually motivated to get things done. And the courts, by leaving this undefined relationship, have really magnified these problems. Now, the good thing about the ACA case, the Burwell case, is that Judge Collier did in fact find that Congress had standing to bring that case. And I think that's a very important step. And I think that the courts are looking at standing again, that it has grown to a point where in some cases you have constitutional violations, but you can't think of anyone who would meet the standard for standing to bring it before a federal court. So I do think that much of our problems today, or many of our problems today, would be rectified for courts to become more engaged in those separation of powers fights.
Yuval or Jim?
Well, I'm a little bit reluctant to see the courts get too involved in this. I've changed a little bit on this, not because I'm conservative, but because I've seen the courts have done a little bit better than I thought. But basically, in our system, it's the Congress that has to defend itself. And as Jeb Bush would have said, put its big boy pants on. And it has to defend itself, and the core of this conflict has to be between a Congress and a presidency. That's how I think this issue of the war powers has been, to the extent it's been resolved, and I think it's been resolved in some measure, has been resolved finally by Congress standing up. And I don't see how any court of law could have had the pretension to come in and say, this is what war is, this is what you have to obey. It's not the way the system works. I believe the Constitution is maintained in part by the Supreme Court playing as a policeman. That's a minor part. It's largely has to be maintained or it'll die. It has to be maintained by the institutions using all the resources that they have to stand up for the lines as they interpret and defend them. And that's what finally emerged, I think, post-Korea and maybe even post-Vietnam, but it emerged, I think, on the eve of the first Gulf War. And we stuck to that pretty much since then, maybe with the exception of the war in Serbia, but we've stuck to it. If you want to have a real war, however defined, rather than a police action, if you want to have a real war, you have to come to Congress. And I don't think any president is going to violate that. And it never happened with the Supreme Court decision. So this is how they worked it out. And what the Constitution means in areas like this is, at any point, is not a legal rule. It's the state of balance that's been achieved by the two institutions using the powers they have to defend the Constitution as they see it. So I'd like to see the court play some role, but I fear that the umpire, if it was regarded as absolute, would become too absolute altogether. And instead of worrying about an imperial president, we end up worrying about an imperial Supreme Court. If you know, nothing against you, Jonathan, I love your commentaries, but if you know some of the people in law schools and lawyers, they're not the people I would trust first to be running the country.
Well, I think Jim's in a conspiracy with my students to get me to delay class tonight, but I can't leave on that note. Let me just make make 2 points. First of all, there is this constitutional mythology that it's very a functionalist approach as opposed to a formalist approach. This functionalist approach is, look, the courts don't have to get involved. Let Congress fight to protect its own turf. Congress has tried to fight. You know, do you know how much Congress appropriated for the Libyan war? Nothing. That war was funded entirely off slush money going around the administration. Congress never had a chance to appropriate that. We bombed the capital of another country. We went and took out armored columns. We committed ourselves in that conflict. There was never a vote because Congress didn't have to appropriate anything. But, you know, and the other idea is that, well, you still have the power of the purse ultimately. Under the ACA in the Burwell case, the President of the United States has committed what would amount to $175 billion. $175 billion without the appropriation of Congress. That's what the Burwell case is all about. So the power of the purse itself has been circumvented. So I think that what Jim and I disagree on is really degree. And I respect Jim for saying that he's come around a little bit on that. But we're not going to be able to get stability in the system until somebody is mining the lines of separation. And the framers gave us a wonderfully stable system. The instability you're seeing is because those lines of separation become blurred through this type of functionalist theory.
Thank you. And you all?
Well, I'm closer to Jim here. I think everybody has to mine the lines of separation all the time, and that a lot of what they do should be mining those lines of separation. It seems to me that a lot of what Congress has done is intentionally blur those lines through legislation that creates immense authority for executive and administrative action that is not well defined. And I pity the courts having to figure out what to make of that in individual cases. They're presented with laws that don't tell anybody what to do. Then the administration does something, and the question is that what the law meant? I don't think that's the role that the Constitution is supposed to put the judge in. That's a failure of Congress to legislate.
Let me try to get you over to my side before I leave. I think that we agree on that. I do have a skepticism in some cases of the courts being able to make those decisions. But what I've suggested is that in separation of powers conflicts, where the question is who makes the decision, where the authority lies to take action, those are cases where I think the courts have got to stop abstaining from, because that goes to defining the stability of the system. And this is a great move on my part because I now get to leave and nobody can disagree with me in my presence.
Well, thank you.
I'm sorry,
so
I've
much,
got a class.
Professor.
Thank you very much.
I think this would be a thank you. This, I think, would be a good time to open the floor to questions. We have some microphones here, so please wait for the microphone to arrive since it's being recorded right back there. And please introduce yourself.
My name is Jim Tozy. One way to look at this debate is between what the progressives think and what the conservatives think. Another way is to look at what the career bureaucracy thinks. And if you talk to a lot of the career bureaucracy that writes rules, there's a handful of these issues you discussed where the president was directly involved. But if you talk to many of the career bureaucrats, that is a distant concern. And their concern is that the Congress has put so many procedural requirements on the bureaucracy over the years, more analysis, more this and more that, as opposed to, say, of really controlling a regulatory state by a regulatory budget, which they've never done. But they put all these procedural requirements on, and the career bureaucrats say, we have to find a way. So I think a lot of what you're discussing comes from the career bureaucracy and has nothing to do who's president, whether it's a Democrat or a Republican. And now, an example I'll give you just happened recently. A court, which always doesn't speak real directly, this one spoke very clear. The plaintiffs argued that there was no basis for this rule. And a judge said unequivocally, you must rescind the rule. He didn't even send it back and say, look at it. He said, rescind the rule. What did the bureaucracy do? They issued the identical rules of guidance. And in this case, the guidance was binding because you had to get federal funds. So I wonder what your view is if you strip away progressive versus the conservative view of what the role of the federal bureaucracy is in the push towards the topic that we've addressed today.
Yuval, is the problem executive power per se, or is bureaucracy a separate contributor to this?
Yeah, well, I don't know that you can really quite separate them. I think that the kind of bureaucracy we have is a function, again, of the kind of government we have and of what we expect it to do, which is vastly beyond the bounds, it seems to me, of what the framers of the Constitution imagined the federal government doing. And beyond those bounds functions a bureaucracy, and not just a bureaucracy, but a set of administrative agencies that have a kind of vague and unclear place in the constitutional system to begin with. And attempts to bring them under control generally involve making their work more complicated rather than making their scope less exhaustive. And so, you know, I agree that's an important part of the problem, but I think that part of the way that the Congress takes itself out of these complicated questions is by leaving an enormous amount of discretion to the federal bureaucracy. And ultimately that creates problems that no one is actually equipped to resolve in our constitutional system, and they don't get resolved.
And on that point, Jim, when you set up this division between the area of law and the area of discretion, you know, as a recovering administrative lawyer myself, I thought that actually in lots of areas of law, there's a lot of discretion, right? And so how much of this do you think is sort of a problem of what's been left to Congress, to the bureaucrats?
Well, I tend to distinguish between high discretion and low discretion. Low discretion is frequently what's done inside of bureaucracies with rules. It can be pretty important. For example, at our university now and nationwide, there's now a national court system, effectively, which has been put into place without any law of Congress on sexual behavior of students across the whole nation. What amounts to a court system legislated by an obscure branch, obscure department inside of an obscure part of the federal bureaucracy. So I'd still consider that low. High discretion is foreign affairs, decisions of foreign affairs, emergencies, and times where you have to break laws or do something. So that would be high discretion. That, I think, is especially the province of the executive having a large role. Katrina, for example, when President Bush failed to exercise that discretion and went too much for the law. I think that was a case where he should have moved more under the proper understanding of the presidency and hurt himself and his administration by not doing so. So that's what I mean. Low discretion is a problem because we have, as you've all said, such a large government. I know you could answer this better than anyone since you're one of the few persons in the world, Adam, who understands what's going on inside of the administration, and then only part of it. But when we studied administration, the question was, who runs this administration? And there were three choices in textbooks. Well, it's the president who runs it. Choice two, it's the Congress who runs it. That was the style for a while. And then the third choice was, is it runs itself, which is what this gentleman is saying. I think it's a little bit of all three, but I do think that in recent years the president has been gaining a stronger hand where he wants, not on every minor decision, but he knows what's going on the big things. Look, when a administrative branch of the government, in a way, declared almost all the industry of Western Virginia and West Virginia at an end, that is ending the coal, in the process of ending the coal, President Obama knew about this. President Obama was, if he didn't originate it, was behind it. It's part of his, so signals are sent, and if the bureaucracy, major part of the bureaucracy is not recalcitrant, sometimes it is, the military is a little recalcitrant vis-a-vis the president, but on the domestic sphere, a progressive president with the progressive elements of the bureaucracy, with a progressive head appointed, in effect can pick up an enormous amount of power. And you see this today. If you would ask this question, I adverted to the coal industry, should a bureaucracy be able to make a decision of that magnitude by a rule, with the Congress standing by the side, it's almost insane. It's unimaginable what is happening in this country. And this, I think, explains an awful lot of what's going on in our politics. The representational aspect of government is diminishing and going.
Great. Right here in the middle. Thank you. There's a microphone coming. Sorry. Sure.
Thank you, Gamrose, and I have worked for the federal bureaucracy, specifically in the budgeting offices. Getting back to the power of the purse, we have a system now which is, I mean, the ship has so far sailed, the cargo may be unrecoverable. If we have basically gotten to the position for over probably a century now where the entire power of appropriation has been delegated to another branch of government, effectively, over to the executive branch, through whose budget offices generate the 13 appropriations bill that become what's Congress sort of rubber stamps. Is it possible for us to return, if the Supreme Court were to enforce the formal distinctions among the branches and their powers and get rid of, say, delegation of appropriation of authority by reverting that responsibility to Congress where it belongs? Is that even possible? And do you think that that's necessary to achieve what conservatives might consider a constitutional function in the government?
Mm-hmm. This is important because when you go back to English constitutional history and you ask how the Parliament was able to check the king, it wasn't through passing laws in particular cases. It was through controlling the power of the purse. So it's not as if it's a one-on-one law. This is why I suppose Jonathan and I would have had a basis. Is the power of the purse is the power to exert power outside of the particular realm that's involved just by saying no, and maybe not even no in that area. You try this and watch what happens to your staff. It's gone tomorrow. So I think the trick in this would be, it does lie with the power of the purse, which is extremely powerful and is not properly exploited. If there's anything, I'm not sure it was ever constitutional for the Congress to have given budgetary discretion to the presidency. But if there could be a change, I would say that it has to happen in this way. Any area that the Congress wants to pick for appropriations would be for the Congress to decide and not the law. The law passed by Congress, which now involves the president in vetoing it, the law cannot exclude the power of Congress to exercise that power of the purse in a plenary fashion. So 13, no, I'd say maybe 500 going back to the original idea. The purpose of budgeting, and the budget is not just to budget, it's to control. And we shouldn't use this word budgeting. We should use power of the purse. That's how it was originally understood. It was understood in that sense. So the Congress should be able to do this. And it's this point as well. if it's controlled in that way, the purse, it can be controlled by Congress not acting rather than having to act. When you appropriate, obviously, a law, appropriation law, that means that the president and Congress is involved. But the decision not to appropriate is not a law. It's exclusive to either House of Congress acting independently. And that's what we have to get back to. That's where the power comes, so that these Congress members of the bureaucracy, when they show up to Congress, they should be quaking in their boots instead of being contemptuous towards Congress. The displays that we've seen now are emblematic of really what's going on. The contempt, it really is contempt of Congress.
I would just say I commend your restraint in not applauding wildly at what Jim just said, because I think that's exactly the right way to think about this problem. It's what's happened, if you think about the history of the budget process since the 74 Budget Act. The 74 Budget Act was really an attempt by Congress to out-president the president. They tried to make Congress more like an executive agency by consolidating the budget process in a way that gave Congress more control. But what actually happened was the president used his own advantage, the advantage that only an executive can have, to out-Congress Congress. And you end up having, because there are these 13 massive budget bills, those bills really ultimately can only be written by executive agencies, and they are. Those bills are written by the people who are funded. The kind of work that has to be done to write those bills is not going to happen in the Budget Committee with 22-year-old staffers. It happens in the administrative agencies, and it is done by the people who are supposed to be begging Congress for money. The way to break that up is to make the budget process more like legislation. Smaller pieces that are not tied to this closed process that unavoidably empowers the executive. Congress should always be legislating, and budgeting should always be part of legislating. It would be a dramatic change, but I think if you ask, is it possible to break the power of the administrative agencies over their own budgets, I think it is possible by fundamentally changing the budget process and making it a legislative process.
I saw there was a question right in front of you, sir, if you still have the microphone. All right.
Thanks. My name is Catherine Davis. I'd like to return to this issue of courts exacerbating the problem of a lack of separation of powers by abstaining from cases. Are you familiar with the current Marshall Islands v. United States case that's on appeal to the Ninth Circuit?
No.
Nah. All right. Well, the Marshall Islands brought a suit in the Northern District of California alleging a violation of the Nuclear Nonproliferation Treaty. They said the U.S. wasn't upholding their end of the bargain for Article 6, and they wanted, among other things, this was admittedly not a zinger of a test case. But we'll move forward. They wanted declaratory relief for a federal court to state what the U.S. obligations were under the Nuclear Nonproliferation Treaty. The Obama administration filed a motion to dismiss, saying there's no way in hell a court could have anything to say about any treaty, and the court did grant the motion to dismiss. The case is currently on appeal to the Ninth Circuit. In the spirit of getting back to a sort of separation of powers, do you believe there could be, under a better test case, a way for a federal court to grant declaratory relief stating what the United States obligations were under a treaty?
Well, let me add to that, by the way, Jim. You know, just a minute ago you were saying that the problem is Congress giving away its power of the purse. So Congress is giving it away. Obviously, the executive branch doesn't mind. So this seems like another area where you might warm up to a judicial role in reasserting the separation of powers.
I might, but I don't understand anything about it, but or very much about the courts. Honestly, law is something I ever since graduate school that I seek to avoid. I've read an opinion now and then. I've liked Scalia's opinions, but I've never read a court case from beginning to end except for Bush v. Gore, and that's only because I'm interested in elections. So I don't want to pronounce on this, but my instinct is to keep courts to a minimum, but my ignorance tells me that I should learn more about it before holding forth. I hope this isn't on C-SPAN.
Yuval?
Well, I'm proud to say I'm not a lawyer either, so I'm not useful to you here. But it does seem to me that ultimately, at least as I see things, and again, mostly in the domestic arena, it seems to me that the ways in which Congress has ceded authority to the executive have created situations that the courts are, in fact, ultimately not able to resolve. The problem here is a failure of responsibility by Congress. It may be that the best place to look, given that fact, is the courts, but that fact is a huge problem in our system of government. And the idea that the courts can resolve these problems, and if you just look at the cases I've looked at most closely in the last few years have been about the various Obamacare cases. The questions facing judges in those cases are impossible questions. The statute is intentionally, utterly unclear, and the action taken by administrative agencies is plainly, bizarrely unconstitutional. And it is just not clear exactly who is more wrong than who in this case. But it's pretty clear that both sides are failing to play the roles they're supposed to play in our system of government. And to expect the courts to resolve that is too much to ask of the courts.
Well, we have time for one last question, extremely brief. Fred?
Hi, I'm Fred Barnes with the Weekly Standard, and this is
Fred, there's a
question
microphone.
for Jim Caesar.
The microphone right next to you.
Thank you. And the question is this. You know, the president declared that the Iranian nuclear treaty was an executive order, an executive agreement, therefore giving Congress no role. Congress couldn't, Congress voted on it, but the president said that would have no, wouldn't be a factor that in any event. It seemed like more of a treaty. Does the president, was that in his, the president's discretion to decide what it was? And would Congress have been able, if they had the votes, to actually declare it a treaty and perhaps overcome the president's veto?
Yeah, I thought it was, superficially, was more like a treaty than an executive agreement, and that it was up for Congress to somehow enforce its will against the presidency, a president who way overstepped his authority in that case. So he's entitled to his opinion, but obviously had contempt for a Congress that even was in the hands of the other party. And I can't think of any other way by which this would have been done. I mean, they can, what are they going to do, take it to court? Fine, 3 years later it'll be decided. They would have had to have done it through the power of the purse. Maybe not that time, but the president would have been so aware of the power of the purse that he would know that this could be used against him. You know, suppose half the White House staff was gone tomorrow, or something like that. It's only by that means, I don't think that a one-on-one legalistic process is ever going to do this. That's not how Parliament checked kings. Parliament checked kings by saying, you can go to war, we don't have any, we can't stop you by a law, but you're not going to get any money. So it's that, and since Congress has lost that weapon, in a way, it's invited itself, invited the contempt with which it's now held. It doesn't have the means. And this, as you say, was with a Republican Congress. I think there was some talk about suing, the president. I know they sued him on some other things. John Boehner sued him a few times. I mean, every time something went wrong, John Boehner was running down the street saying he was going to sue them, and more power to him. Actually, as it had a little bit more success than I ever thought with some of these suits. But I would say it has to be from, if you're going to have a separation of powers, the institutions have the means, if they're willing to use them, to protect themselves. If not, we're in big trouble.
Yuval, do you have a word in closing?
I think that's a good way to close.
Great. Well, as it happens, we have somebody here now who knows a thing or two about what a treaty is or isn't, or is at least in a position to say so. So for now, let's thank our panelists, and then we'll briefly reset.
Thanks.
Just a programming note at the outset. Obviously, I'm not Bill Crystal. Unfortunately, he can't make it due to a last second thing that came up, funeral for a family friend. And so you're stuck with me for another 45 minutes. But fortunately for you, you have Senator Lee here to speak to these issues we've already begun discussing in earnest. It's a real pleasure for you to join us today here at the Hoover Institution. Thank you so much for coming. As somebody with a background, not just obviously right now in the Senate, but your previous work in the judicial branch and the executive branch, you're uniquely well positioned to speak to these fundamental issues of constitutional separation of powers, executive power and legislative power that we've been discussing today. And so just for a moment, let me just offer a brief introduction as to your work over the years. Obviously, you've been elected to the United States Senate by the people of Utah in 2010. In the Senate, you've been a vocal proponent of restoring Congress's attention to the Constitution. You've been, both in terms of respecting the Constitution's limits on federal power generally, but also in terms of restoring Congress's power and its central role in the national government. You've been a student of the Constitution all your life, thanks to your father, famously, the Solicitor General for President Reagan, Rex Lee. You received your bachelor's degree and your law degree from Brigham Young University, clerked for Judge Benson on the Federal District Court, and then you twice clerked for Justice Alito, first on the Third Circuit when he was still a judge, and now on the U.S. Supreme Court soon after his appointment. Senator Lee also served as general counsel to the governor of the state of Utah and as an assistant U.S. attorney. And in the, very much in the mold of the late Senator Moynihan, you're an author. You've already published 3 books, at least 3 books. The first one on the Freedom Agenda, Why a Balanced Budget Amendment is Necessary to Restore Constitutional Government. And then in 2013, Why John Roberts Was Wrong About Health Care. And then finally, and most recently, Our Lost Constitution, The Willful Subversion of America's Founding Document. Now, in recent months especially, you've returned to the subject of Article 1 of the Constitution with your new Article 1 project, and so we're very pleased to have you here today to discuss that project and to speak more generally about the Constitution's separation of powers.
Great, thank you. You know, as we've been honoring the late Justice Antonin Scalia, I'm continually reminded of a number of circumstances when I heard Justice Scalia speak about the Constitution. One of the things that he liked to say, in part because it was provocative, it got people thinking, was that of all the provisions that are in the Constitution that are important, he didn't necessarily think of the Bill of Rights first. He would say, no, I love the Bill of Rights. We need to enforce the Bill of Rights. But, and this is his term, not mine, but any tin-horn dictator around the world can have a Bill of Rights. And that Bill of Rights may or may not mean anything, depending on whether there are structural protections built into the Constitution. There are, I believe, 2 very important structural protections built into the Constitution that are probably as important as, if not more important than anything else in there. They are the vertical protection that we call federalism and the horizontal protection that we call separation of powers. It is this latter protection, the horizontal one, that I want to discuss tonight, and that is the primary focus of the Article 1 project that I've helped to start in Congress. As I wrote in the book that I came out with a few months ago called Our Lost Constitution, by the way, all 12 people who have read that book have really enjoyed it. You could be the 13th if you're interested in reading it. But as I explained in that book, there has been a long process by which Congress has voluntarily relinquished its authority. Members of Congress like to speak of themselves as though they were somehow victims of an overbearing administrative state, an executive branch run amok that is beating up on the poor old Congress. When in reality, Congress is the perpetrator in this offense, not the victim. Congress has voluntarily done this to itself over the last 8 decades. And it has done so steadily. It has done so with the understanding that every time it relinquishes a little bit more of its lawmaking power, it becomes less accountable to the people. It's bad in every single respect imaginable, in every policy respect, in every constitutional respect. It is good for only one thing, which is facilitating the perpetual re-election of as many members of Congress, both houses, both parties, as possible. This is the only respect in which you can defend it. And yet this is not a good constitutional reason, nor is it a good policy reason. I keep 2 stacks of documents in my office to serve as an ongoing reminder of this problem. Stack 1 is a few inches tall, and it's a few 100 pages long. Stack 2 is 11 feet tall, it's 80,000 pages long. The short stack consists of the laws passed by Congress last year. The long stack, the 11-foot tall, 80,000 page long stack, consists of last year's Federal Register, the annual cumulative index of all regulations as they're proposed, released for notice and comment, and later for finalization. A significant portion of that 80,000 page stack consists of legally binding documents. For all intents and purposes, those are laws. But they're laws put in place not by elected senators and representatives. Instead, they're laws put in place by executive branch bureaucrats who will never stand for election. Now, I want to make one thing very clear at the outset of my remarks. In addition to the fact that I blame Congress as the culprit here and not the executive branch, I want to make very clear, I'm also not trying to disparage the hardworking, well-educated, well-intentioned, and generally highly specialized men and women who work within our executive branch bureaucracies. They're just doing their job. Now, some of them come out with policies that I think are horrible, policies that will make our nation weaker or poorer or less fair, but they are nonetheless more or less doing the job given to them by Congress. And so this truly is a problem that Congress has created, that Congress has to fix. It's one of the reasons why I joined together with Jeb Hensarling, Congressman Jeb Hensarling, Chairman Jeb Hensarling in the House, and we put together an internal think tank within Congress consisting of 10 members. Senator Flake and I in the Senate, and 8 members of the House of Representatives, including Mia Love, Barry Loudermilk, Cynthia Lummis, and a handful of others, with the idea of helping Congress to reclaim and begin to exercise anew its legislative power. It is no accident that the very first clause of the first section of the first article of the Constitution reads quite simply, all legislative powers herein granted shall be vested in a Congress, which shall consist of a Senate and a House of Representatives. The Founding Fathers didn't want that power, the power to make policy, to establish rules carrying the force of generally applicable law, to be exercised by anyone who is not elected. So our think tank is there to come up with ways to rein in regulatory power, to reclaim the legislative power of Congress, to limit executive discretion, to reclaim the power of the purse, and to end the practice of governing by cliff, all of which share some commonalities within them, and all of which have involved a steady diminution of this horizontal separation of powers that we have in place and that we need to be following.
Great. Well, of the 4 parts of the Article 1 project, we'll get to those in turn, but at first I'd like to begin with the very beginning, with James Madison, who we spent a lot of time discussing in the previous panel. He famously said in Federalist 10, the legislative department is everywhere extending its sphere of activity and drawing all power into its impetuous vortex. Obviously, that's no longer the case, or that's your argument. What has caused this change, that you now have to stand up for Congress again as Congress, instead of the scenario the founders feared, which was Congress standing up too much and pushing too hard against the other branches of government?
It is as though the polarity has been switched since the time Madison penned Federalist 10. And I believe you wrote something about this a couple of years ago, talking about how Congress now has an incentive and has reacted to the incentive to not only accumulate more power, to accrete more power to itself, but to get rid of as much of it as possible, to not exercise that power, for the simple reason that it tends to be a political insulator. When we don't exercise the lawmaking power, we can pass the buck along to somebody else. So imagine a hypothetical or not so hypothetical scenario in which Congress passes a law, or let's say considers a law. It says we shall have clean air. Now what idiot's going to vote against that? We shall have clean air. Everybody likes clean air. They want to breathe clean air. They understand that clean air or dirty air moves from one state to another, that there is very much an interstate channel through which pollution travels. And so this is not an inappropriate exercise of Congress's power to legislate in this area. And yet, when you look at the fine print of a bill like that, if the fine print says essentially, and we hereby delegate to the EPA the task of defining clean air, the task of defining pollution, the task of coming up with penalties that will be imposed upon polluters, and filling in basically every other detail behind that law, you're going to have a few interesting things happen. Number one, the people at EPA are not necessarily going to write the same laws that members of Congress would write. And I don't care whether it's a Congress run by Democrats or Republicans. And I don't care whether it's an EPA working under the leadership of a Republican or a Democratic president. They're going to come up with very different solutions for the simple reason that one is an elected representative institution, Congress, and the other is not. And so when that happens, you have this odd thing that occurs where members of the public will come into Congress and they'll say, look, just to cite one example, EPA has now come up with an ozone rule that has set the ozone limits below the naturally occurring ambient ozone levels in many parts of the country. This is a true fact. I mean, in many parts of my state, we have ozone that, as it exists in a state of nature, is higher than where EPA has set the limit. And so people say this makes no sense. And then members of Congress say, oh, I agree with you. Those barbarians at EPA. You know what I'm going to do? I'm going to write a harshly worded letter. And that's about the end of it.
So, okay, well, this gets right to one of the 4 pillars of the Article 1 project, the problem of regulation, the issue of regulation. And there's 2 parts to it. There's the substance, which you just discussed, the delegation of powers to the agency. And there's also the procedural side of things, right? The way that the Congress makes sure and the courts make sure the agency goes about its work. Right? Are those both parts of what you've been focusing on, or are you focusing first and foremost on the substantive side of these delegations?
No, we're focused on both of them, and they really are 2 sides of the same coin. You can't really address one without also addressing the other, and they both do need to be addressed. And so, yeah, we're focusing on both of them at the same time.
So is the idea as to substance to draw back these delegations?
Yes, to draw back the delegations and to take care that in the future, additional attempts to delegate legislative power need to be handled differently. Now, the way that this was handled initially, when you research this, and I talk about this in my book, that James Landis, who was one of the members of FDR's brain trust, who helped FDR set up the original administrative regulatory system, he recommended at the outset, he said, Mr. President, in order to make this work, in order to have it function properly under our constitutional system, these regulations, if they carry the force of law, really do need to be run back through the Congress, treated kind of as legislative proposals, passed by Congress and signed into law by the President. If you do it that way, we'll be following the constitutional order. Somehow, FDR either never got the memo or never internalized the memo. It didn't really happen. But they did start this process known as the legislative veto, where they said, rather than have to go through that whole process again, let's just make it so that certain regulations can be invalidated by an act of Congress alone, without submitting that act of Congress back up to the President for signature or veto. This acquired a lot of popularity between the 1930s and the mid-1980s. Congress had done this hundreds of times. When the Reagan administration said, wait a minute, this isn't quite right, something's wrong with this, the Reagan administration challenged it, and eventually the Supreme Court agreed, and in the mid-1980s, the Supreme Court decided INS v. Chadha, concluding that that violated Article 1, Section 7's presentment clause. A lot of people would have predicted at that time, and did predict, in fact, that this excessive delegation would stop. Because after all, Congress wouldn't be so crazy as to delegate that power without having the last word, without reserving to itself the ability to invalidate a regulation. But no, that didn't happen. Quite the opposite happened. We went on a feeding frenzy after that. I mean, I say we. I was in junior high when Chadha was decided, but Congress as an institution went on a feeding frenzy and continued as if nothing had ever happened. In fact, if anything, it has accelerated the pace since then. And so what we need to do is go back to that. We need to pass, first of all, the REINS Act, which is a legislative proposal that's been passed by the House every year for the last 4 or 5 years in a row, that says simply anytime there's a new regulation that amounts to a major rule because of the fact that it has a significant economic impact as measured by OMB, that would be treated as a legislative proposal. It would be treated as a bill, and it would be fast-tracked through Congress, and only after that proposal had been enacted by Congress and signed into law by the President could it become law. That's one of the first orders of business. We want to fine-tune that, make sure that it does it the right way, but we support something like the REINS Act. We also need some type of regulatory budget legislation so that we can look at the total aggregate regulatory compliance costs in our country and put it in a box so that it can't exceed the volume of that box. In other words, when I was in law school, I was shocked to discover that federal regulations were costing the American economy $300 billion a year. You know, that's $300 billion, I learned, that really was being paid by America's poor middle class disproportionately. It's like a backdoor invisible tax that nobody ever sees the bill for. Well, now that number's up to $2 trillion a year. disproportionately affecting America's poor and middle class. We all pay for that with higher prices on goods and services, diminished wages, unemployment, and underemployment. But nobody's aware of that. They're not as aware of it as they should be, and that number is always expanding. So we want regulatory budget legislation putting limits on how much we can, how many regulatory compliance costs we can subject on the American economy, such that when you add a new regulation, you got to take something else out.
Okay, and related to the issue of regulation is another pillar, let's say, of the Article 1 project, which is executive discretion more generally, right? Now, what can Congress do, or what should Congress do to rein in executive discretion?
Here we have to be careful about the way we phrase legislation. So there's some of these procedural issues that I mentioned with the REINS Act and things like the Regulatory Budget Act. But we also, this one is more of an intangible. This one is harder to define in a single piece of legislation. But we need people in Congress to be aware of the problem of loosey-goosey standards that we hand off to the executive branch. If we tell the Secretary of Health and Human Services that she shall have power to make good rules governing X, Y, or Z in the healthcare industry, that's not going to do us any good. If we put meat on the bones, then we'll actually be making the determinations ourselves.
Now, under the statutes as they currently exist, there's this issue of what's called Chevron deference,
Yes.
right? Where the courts give significant deference to the agency's interpretation of the law, so long as it's reasonable. But when you're dealing with a statute that's written in the broadest possible words, it's hard for an interpretation not to be reasonable, right? So is this something you've looked at in terms of something that needs to be reformed, Chevron deference itself?
Yes, absolutely. I'm looking at that, and one of the things that we'll be addressing through the Article 1 project is the need for a legislative change, a legislative modification to, and in fact, an abandonment of the Chevron deference standard. Look, this was created out of whole cloth within the judiciary. There is no reason, there is no good reason, no reason that makes sense on this planet why the courts should defer to an agency's interpretation of Congress's legislative language giving that agency power to act. I mean, talk about handing the keys to the hen house over to the fox. This makes no sense. And there's nothing in the APA that requires it, nothing in the APA that even allows it. And that's one of the reasons why, by statute, we need to get rid of Chevron deference. It never made sense, and it doesn't make sense today.
Now, not to get too focused on Chevron, but as a lawyer, I feel like I have to ask one more question about it. I mean, one of the justifications for it at the time was that at least the agencies have some sort of democratic accountability through the president, right? Whereas the courts, when they're sitting and interpreting these laws themselves, they're unelected judges. So that's at least one justification for it.
Right. And that justification fails when you peel back the logical layers of it, which aren't really that deep. I mean, this is what courts do. Yeah. They read laws. Those are the tools they have. Courts don't have a lot of other things. They don't have political accountability. And one of the reasons why they don't have political accountability is that they've got one task, which is to read the law and tell us what it means when two or more parties can't agree as to the law's meaning. That's what they're there to do. And so this really grew out of, I don't want to say laziness, because I really do respect our federal judiciary. We've got our federal judiciary, despite faults that we can point to, is the envy of the world. And it is a great system. It's a system that I would stack up against any state court system in the United States, and certainly against the legal system of any in the world. And yet this one makes no sense. It makes no sense that the courts that have the interpretive tools at their disposal and know how to construe statutes should just say, you know what we're going to do? We're going to defer to this agency, because after all, they should be in control of their own interpretation of their own statute that they are interpreting, that they are enforcing, and that they're using as a base from which to launch an independent legislative effort.
Now, separate from the work of writing the laws, Congress's other primary constitutional task is to hold the power of the purse. And that's an issue we talked about quite a lot in the previous discussion, especially James Madison. The last quote, we've quoted a lot of Madison today, but his point in Federalist 58 that this power over the purse may in fact be regarded as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people for obtaining a redress of every grievance. So they saw this from the very beginning, but that process, you argue, has broken down in recent years, right? And there was a question during the previous discussion about Congress even giving away its power of the purse effectively to the agencies, allowing them to fund themselves. What is your project sort of seen in that issue on appropriations?
Yeah, so just as on the legislative side of things, on the policy making and non-budgetary side of things, Congress does need to reclaim its power of the purse, its spending power. Madison was absolutely right when he wrote that in Federalist 58. And what was true when he wrote those words remains true today, that this is the greatest weapon that the people have against encroachment by the government against the people. But it has to actually be exercised. You have to invoke it. You have to do it in order for it to work. In the same sense that if you don't use the brakes in your car, it will not stop. If Congress doesn't pull on the reins when it comes to spending, that power will be rendered vestigial, sort of like the appendix. And so we have to start doing it. In order for that to work, we've got to reform the way we spend, and we've got to stop governing by cliff. You know, one of the sad things that I've seen happen over the last few years is that Congress has tended to push all spending decisions into a single bill. Sometimes we call it an omnibus, sometimes we call it a continuing resolution. There are significant differences between the two, but I find that when I try to explain the difference between a continuing resolution and an omnibus, most people stop listening to me and they get very bored. But when all spending decisions are put into a single bill, when the spending that has been authorized, whether the money that's been appropriated for the previous fiscal year is about to expire, and then somebody rolls out a 2,242-page omnibus spending bill 48 hours before that funding stream is going to expire. And then members of Congress are told you've got a binary choice. You can vote for this and everything in it, over $1 trillion, 2,242 pages long. And by the way, you won't have any opportunity to amend it, to improve it, or even adequately to read it. But you'll have that warm, fuzzy feeling that comes from knowing that you kept your government funded. Or alternatively, if you want to be a jerk, you can vote against it and risk shutting down the government. That is a very horrible way to run a government, especially a government that is supposed to be government in a free republic. A free republic can't operate as a free republic unless the elected representatives of the people in a free republic actually have some say in it. They don't have any meaningful say in it when it runs like that.
So what's the alternative?
The alternative is to put forward legislation much earlier in the year, long before the cliff arises, so that meaningful debate and discussion can happen. Now, there are those who insist upon the absolute need to have at least 12 spending bills put forward and passed independently. I don't dispute that we would be better off having a dozen or even more separate spending bills come up for consideration and passed and debated and discussed independently. That is, after all, what the Budget Act contemplates and requires. We typically don't do that. We haven't done that in many years. It just hasn't worked that way. But that part of it is not in the Constitution. That part of it was not written either on parchment in 1787, or was it carved into stone tablets and handed down on Mount Sinai. That part of it is something that people came up with in the early 1970s. It is what it is. Far more important to me than having, whether you have a dozen or 112 or 150 or 200 separate spending bills, or just one spending bill. Far more important to me is the amount of time that we spend debating, discussing, improving, and amending that legislation. That's what allows the people to have input into the spending process, and that's where it needs to happen. I would much rather have one spending bill with a very lengthy amendment and debate process than I would a dozen or even 100 spending bills that are not adequately debated and subject to amendment.
Now, in the previous discussion, Yuval Levin touched on a point that I thought was very smart. This point that a lot of the problems we see in the growth of executive power are actually really just rooted in or exacerbated by the growth of federal power generally. Right now, before you were talking about the problem of administration and Congress's lack of authority relative to the president. You spoke at length and wrote at length about federalism more generally. How does that fit into this new Article 1 project?
It always makes me really happy whenever I can merge a discussion of the dilution and the erosion of the horizontal protection that we call separation of powers with the erosion of the vertical protection that we call federalism. They really are connected. The fact is the federal government is doing too many things that it was never intended to do. And I don't mean this to be a politically charged statement, and in fact it is not. This is an issue that in and of itself is neither liberal nor conservative. It's neither Republican nor Democratic. This is a simple point that the Founding Fathers understood that there was a distinction between purely local activities, even purely local activities that were economic in nature that had an impact on interstate commerce, and activities that are themselves interstate and economic. We have lost that. I think one of the most pivotal moments in American history when the Constitution was changed in a very dramatic way was not the moment when any of our 27 amendments were drafted or proposed by Congress or ratified by the states. It was instead on April 12th, 1937, which, as I explained in my book, is the day the Supreme Court decided the seminal case of NLRB versus Jones and Laughlin Steel. This is when Congress started shifting toward an interpretation of the Commerce Clause that is essentially open-ended. An interpretation of the Commerce Clause fully embraced and evolved within 5 years after that in another case called Wickard v. Filburn, a case that says Congress, in addition to regulating channels and instrumentalities of interstate commerce and objects moving in interstate commerce, interstate commercial transactions, Congress may also regulate any and every activity that, when measured in the aggregate, has a substantial effect on interstate commerce. It is fair to say that under this standard, virtually every aspect of human existence, virtually every human activity may be regulated properly at the federal level. So how does this relate to the horizontal separation of powers? Well, it does precisely because when we load too many things onto the federal government, we make it virtually impossible that one legislative body, and for that matter one executive, but especially one legislative body, can effectively manage and oversee all of the machinery that goes into that. It just isn't humanly possible. And so unless we are to become comfortable as a society with the notion that we will just outsource all of this to experts in Washington, D.C., experts who are neither elected nor accountable really to anyone who is elected, if we're honest about how it really works, then this is never going to work. Unless we follow the vertical protection and consider ourselves bound by it, we will never fully be able to restore the horizontal protection.
That's an argument that will resonate among conservatives and libertarians and those who share your criticism of those New Deal era Commerce Clause interpretations. But what does the reassertion of congressional power over executive power, what does that sort of, what's the benefit there for those who wouldn't agree with the premise that the federal government is too large? How does the Article 1 project speak to those on, say, the left side of the political aisle?
Okay, that one's easy. I thought you were going to ask me the question of how you make federalism sexy for liberals, and I'm happy to answer that one too if you want me to get there. But the question you have asked me is even easier to answer. If you are a liberal, or if you're not, imagine that you are for a moment. If you are a liberal, or you can imagine that you are one, perhaps you're very content right now with the fact that you've got what someone most would regard as a pretty progressive Democratic president. A few years from now, a few months from now, might no longer be the case. We might have someone in the White House who was a Republican, perhaps even a very conservative Republican. And at that point, you might be concerned with the way that president might act. You might see that president pushing through the administrative machinery a whole lot of changes to the law. And as long as that president goes through the motions, follows the APA and otherwise dots the right I's and crosses the right T's, then that president's going to be able to almost single-handedly change a whole lot in the law. You don't really want that, do you? And in fact, the branch of the federal government that is most accountable to the people at the most regular intervals is Congress. Wouldn't you really want that protection there? I mean, this one really is not politically charged. It shouldn't be. And I actually expect that the moment we have a Republican president, we're going to see a huge shift. You're going to see a whole lot of Democrats get on board with the REINS Act. The REINS Act was introduced for the first time just a few years ago, about the time I was elected to the Senate, either just before or just after. I'm an original co-sponsor of it in the Senate. It has enjoyed very little Democratic support. I predict right now that that will change as of January 20th of next year, if in fact a Republican president is elected. Can I get to the federalism part?
Yeah, of course,
I'll be
of course.
brief. This one's not always as obvious, but I still think there is a compelling case to be made that even if you are a liberal, let's say you're a very progressive Democrat, maybe you have a much broader vision of what the role of government is, a vision that is far broader than your conservative or libertarian friends might be willing to embrace. Perhaps you believe that the best kind of healthcare system is a single-payer, government-run, government-funded healthcare system. Well, there are states in the country where that is the majority view. I'm told, for example, that in Vermont, most of the people and most of the people's elected representatives in their state legislature are firmly of that view. But for the fact that we've completely neglected federalism as a constitutional mandate, a state like Vermont would be much more capable of setting up its own single-payer, government-run, government-funded healthcare system entirely within the state. It's almost impossible to do that, given how heavily invested and heavily involved the federal government is in the healthcare system. And so that makes it almost impossible for a state like Vermont to experiment with something like that. If they want to move in that direction, they ought to be able to. And there are lots of other examples that we could point to.
Well, we have a few more minutes, and I just have a couple more questions for you. Thank you very much for your time. Nature abhors a vacuum, and it's often been said that the reason why this particular administration has sort of jumped in with policies without congressional action is that the administration is acting where Congress wouldn't. And so I'm curious, to what extent would reassertion of congressional power require Congress to set aside things like the filibuster or other procedural constraints that delay or prevent Congress's own action?
Yeah, I don't accept the premise that congressional inaction is brought about by procedural protections like the filibuster. That's there to ensure open, robust debate. To the extent we follow it, it enhances debate and discussion in the Senate. It doesn't allow it to be chilled, and I think the people as a whole benefit from it. The fact that there is congressional inaction on a lot of things has a lot to do with the fact that there isn't adequate consensus on a whole lot of issues, and that the trust between the White House and the Capitol has broken down. But as much as anything, I think it has to do with the fact that we've made it very possible, in fact, we've made it very easy for the president to act this way. I don't like it one bit when we have a president saying, I've got a pen and I've got a cell phone and I can change the law as I want. I'm paraphrasing there, particularly with the end of that. But in a sense, we've kind of opened the door for that by passing laws over the course of many decades, giving the president and giving officials within the executive branch an enormous amount of discretion. by passing laws that aren't really laws but are mere aspirational statements. And that creates a big problem. But no, I wouldn't blame this on things like the filibuster. I don't think that's what this is about.
Now, in addition to the writing of laws and the power of the purse, the Senate's other main tool is its role in appointments. And obviously this is going to be quite a year in that respect, at least with respect to the Supreme Court. I've seen you write recently on the Senate's role in the Supreme Court confirmation process, and I'm just curious if you could sort of give your vision of what a robust congressional role in the appointments process looks like.
It's important to remember that this is a shared power. This is not a system in which the president has the power to nominate someone and that person gets appointed unless Congress vetoes it. That kind of model was proposed at the Constitutional Convention and it was rejected. In fact, during much of the deliberation during the summer of 1787, the thought was that the Senate itself would have the appointment power, that it would belong to the Senate. Ultimately, what was adopted was something that was based, I believe, on the Massachusetts Constitution of 1780, in which it really was a shared power. So the president has the power to nominate, and if the Senate gives its advice and consent, then the president may appoint people to those positions. There's nothing in there that requires us to act within a particular time frame or to act at all. This is a contingent power. In other words, the power to appoint contemplates not only nomination but also confirmation. Without both of those two things, neither of which can be deemed guaranteed with respect to any individual, with respect to either the president or the Senate, you do not have appointment. And so this is one of the many reasons why I think that this part of it really is up to the Senate. And I understand that not everyone is pleased with the way we choose to exercise our power when it comes to advice and consent. But I respectfully but strongly disagree with them when they say that we're somehow subverting the Constitution by making a choice not to process a particular nomination.
Now, hopefully the conversation can continue when we move on to the refreshments afterwards. I do have one last question. And in a sense, this is a little bit biographical for you. I mean, some of the things we've discussed today, the growth of executive power, the role of Chevron deference, the president's role over the agencies, a lot of these were accomplishments of Republican administrations, especially the Reagan administration. And so what would you say to your fellow conservatives who are now looking at sort of the end point of some of these accomplishments, right? That maybe this pendulum has swung too far in one direction and it's time to reverse course the other way. I mean, many conservatives, including those who lived through a lot of those battles in the 80s and afterwards, in some ways you're asking them to reverse course slightly or reconsider what some of the implications of their accomplishments. What would you say to conservatives who are looking at reforming the achievements of past conservatives?
I don't view it that way. I don't believe I'm proposing anything that undoes anything accomplished by the Reagan administration. I mean, yeah, the Reagan administration did push back in response to what it perceived, in many instances appropriately perceived, as encroachment by the legislative branch on its domain. And yeah, this thing can go both ways. I mean, it was a bold move by the Reagan administration, for example, to file suit, or to take the position it did, rather, in INS v. Chadha. Jagdish Rai Chadha was a Kenyan of East Indian descent whose stay of deportation granted by the Attorney General had been itself subject to a legislative veto within Congress. And ordinarily, it would have been the job of the Justice Department to defend the act of Congress that was the subject of this challenge. Ordinarily, that is what the Justice Department does, and when it gets to the Supreme Court, it's the job of the Solicitor General to defend the constitutionality of that law. But in that case, the Reagan administration decided to act boldly and take the unusual step of saying, do you know what, we agree. This is unconstitutional. Congress shouldn't have, and it doesn't have, consistent with the presentment clause of Article 1, Section 7, the power unilaterally to undo that bell which has been rung by the executive branch agency. They were righting a constitutional wrong, and there's nothing about this that undoes that. Nor is there anything about this that undoes another executive branch theory that's popular among conservatives, which involves the unitary executive theory. The idea that the executive branch as a whole does need to be and is properly under the control of the President of the United States. It's what the executive branch is. It's an extension of the President. There's nothing about this that is inconsistent with that either.
Do you have another book in mind?
You know, one of these days, my wife tells me I need to write a book about vampires, or you know, something that people
Another
really
book
want
about
to.
bureaucracy.
Yeah, exactly. When I decided to write our lost Constitution, she questioned whether a book about Article 1 was really going to sell, and she was right.
Great. Well, thank you very much for your time. This has been very enjoyable. Thank you.
Thank you.